We'll be learning about Mahony versus Holyford Mining Company and also why is this case important. So, intro of this case is a key decision in the English company and it particularly states two doctrines, which is the doctrine of vendor management, which is also called Turquoise rule, and also the doctrine of constructive notice. It further established principles on how third parties dealing with the company are protected when they rely on apparent authority. Third parties blindly rely on the company and sometimes the company is not following proper procedure. So this case law is a perfect example to showcase how frauds and how the third parties are sometimes penalized for things they haven't even done. The next is the importance of this case. Why is this case even important? First is it strengthened the indoor management rule. In the next slide, we'll be learning what is the indoor management rule. Next is that it protects the company, it protects the third parties. So outsiders dealing in good faith are not penalized for the internal company irregularities. And it also says the company cannot escape obligations. So if the company has done something wrong, the court will penalize the company and the company will have to pay for its wrongdoings. So officers acting on behalf of the company can even be bound by this. As earlier said, we'll be doing doctrine of vendor management. Doctrine of vendor management protects the outsiders who are dealing with the company in good faith. The outsiders sometimes blindly trust the internal procedures of the company, even if they haven't been followed. And however, it doesn't apply, the outsider already had the knowledge or suspicions of the wrongdoings. Suppose if the outsider is already involved with some internal management of the company and is aware of the wrongdoings, so this won't be followed then. Next is the doctrine of constructive notice. Doctrine of constructive notice states that the company has two official documents, which is MOA and AOA. So, when the company has been registered with the registrar, the company publishes those two documents on the official government website, and the company believes that all the third parties who are forming a contract with the company have followed and read those MOA and AOA and have also understand them in the right sense. In the right sense means like what the company really wants to state, they have understood that only, they haven't taken any literal meaning out of it. So yeah, the third party is presumed not only to have read but understood the two perspectives, and every person dealing with the company have read the other documents also. Then we come to the main case law, Mahony versus East Holyford Mining Company. So the case law which happened was that the directors have signed a check to the third party, and according to the company, either 2 or 3 directors had to sign the check, or even the secretary. So here the secretary signed the check and gave it to the bank. The bank made the payment to the third party. Later on, it was discovered that neither the director nor the secretary had been officially appointed by the board. And in this case, if they haven't been officially nominated, the check were not to be passed. So after the check was passed and the payment was made, the company sued the bank for the amount paid against the check. The company argued that the checks were not signed by the authorized person, and if they were not signed by the authorized person, it was the duty of the bank to inquire further before making the payment. But the company referred to the principle of constructive notice and believed that the bank would have gone through the provisions which are already stated, and if the special resolution has been passed, then why should the bank inquire everything again? The bank got the formal copy of the check, the bank got the formal copy of the resolution which have been passed, it got all the official documents. So why should the bank check whether the directors have been appointed officially or not? And it is also a very interesting case. Even if you are dealing with a company, you would never in your right sense think that, okay, this can also happen, that the directors have not been officially appointed or the secretary have not been officially appointed. It was said that the non-payment of the authorized person for signing the check was a matter of internal management, and third party were entitled to presume that the directors have been appointed properly. And since the bank received the formal notice in the ordinary way of board's decision, it was not bound to inquire further. Yes, it was not bound to inquire further. It was not the mistake of the bank. It was a mistake of the company. So then this case was taken to the courts, and the bank and the court, the House of Lords, stated that the bank was not responsible. It was the company who was responsible for not making the official things. And the check was a matter of internal management, and the third party who received those checks were entitled to presume that the directors had been properly appointed. And since the bank had received formal notice, it was not long to inquire further, as I already stated. So the House of Lords said that it was the mistake of the bank. It was the mistake of the company and not of the bank. The bank was right on its part. It said that it was, here the doctrine of internal management comes in. The doctrine of internal management here protects the third parties. So the House of, as you can see in the slide, it is upheld by Section 176 of the Companies Act. Section 176 of the Companies Act expresses that imperfections in the arrangements of the directors and chiefs and does not discredit the other third party. Next is the importance of this doctrine. It protects the doctrine of constructive notice, protects the company's internal looks, whereas doctrine of internal management protects the third parties. Doctrine of constructive notice prevents frauds and unauthorized transactions, and same goes with internal management, but it protects from the third party's perspectives. So the exceptions to the doctrine of constructive notice is the doctrine of internal management, and this is a very important question. Yes, the doctrine of internal management is the major exception. Then the lack of authority. Yes, if the contract is beyond the company's powers in the MO and AOA, so then this doctrine would not be followed. Knowledge of irregularity. If an outsider already knows about the internal irregularity, then they cannot claim protection, as I stated earlier, if they are already in contact with the company. Fraud. So even in case of fraud or misrepresentation, this will not be followed.